February-ish?
Late February, early March, yes.
And as far as the phone itself, are you aware of whose name that phone was actually in?
I believe it was, yes, I've seen the paperwork. I think it was the mother's, maybe. I don't remember whose name was in, but I have seen it.
It was not Trayvon Martin's, correct?
His name was not on the bill, correct, or the account.
Okay. And this was actually a phone on a family account, one of several on that account. Am I right?
I believe that's correct.
Okay. And can you tell me, you referenced this discussion over a gun. You said it was between two people and either one or both of them was either trying to buy or sell a gun?
No, there were the different conversations I identified. There were 4 or 5 or 6 different ones. In each of them, well, in most of them, Mr. Martin was looking to purchase a gun. In one, there was a discussion about a gun, somebody else's gun, and in the last one, somebody was trying to buy one from Mr. Martin.
Okay. And this was a .22?
There were discussions about several different calibers.
Okay. Obviously, none of which he had on his person the night he was shot and killed by George Zimmerman.
That's what I've heard.
Okay. You know what caliber that was, right?
I don't. I'm sure you guys do.
All right. As far as this, these discussions about fights or fighting, in any of them is, let me just ask it this way. In any of these discussions, can you tell me who was operating the keyboard at the time the message was sent, the keypad?
Let me answer it this way. Number one, I was not there when the messages were typed. However, when you view 8,000, 9,000 text messages on a phone, you get a flavor, you get the cadence of the people, and so you get I think I can get a pretty good idea of whether it's the same person or not.
Is that a long way of saying you would like to think so, but no, you can't tell me for sure?
Again, I was not there when the messages were typed, but would they all appear to be by the same person?
Or when the photos were taken, right?
I was not there, correct.
And in fact, as to the photo, what we've called the profile photo, it looks like you have that on the exhibit there as 3 separate dates, 11:15, 11:30, and 2:10?
No, that's the date. That's the data from the phone. It's on there 3 times.
Okay, but it's the same picture.
Yes.
All apparently originally created on 11/15 of 2011.
Probably, yes.
Okay. So we're not talking about 3 different pictures, 3 different profiles. It's the same picture, just repeated a couple times.
Correct. They have the same hash values, which means it's the same picture.
Okay. And that, of course, the profile picture has nothing to do with hands or guns or any of that being visible. It's simply basically just a torso and face shot of Trayvon Martin, right?
Correct.
Okay. And it's not posted in connection with either fights or guns, right?
Posted in terms of text messages?
Right.
Correct.
As far as this deletion, deletion can be accomplished by anybody who had access to the phone and knew the app and how it worked, right?
And the codes to get to it, yes.
So as we've discussed, you weren't there to tell me who, if anyone, actually did any of that as it relates to Trayvon Martin's phone.
I was not there when.
When were the deletions accomplished? Were they done all en masse, or were they done little by little?
I cannot tell that.
Can't tell that.
No.
So, just asking you a hypothetical as an expert.
Mm-hmm.
If a person, parent or sibling or whoever, had discovered stuff in a phone and deleted it, you couldn't tell me whether that was done like that time all at once, or whether, for example, if we assume that the daily user of this phone was Trayvon Martin, he deleted things as he went along. Can't tell me which one of those that might have been.
I can give you my opinion.
Okay, based on, I thought you just told me you couldn't tell.
No, there's nothing in the data that tells me when a particular deleted text was deleted.
Okay.
But as you look at it, you can see that certain ones are deleted, certain ones are not deleted,
Sure.
and you can look for patterns. So
But as to when that got done, you can't tell me.
that is correct.
Certainly as to by whom, you can't exactly tell me, although
Well,
I understand you have a suspicion.
I
get
was
that.
I was not there when the texts were deleted.
As far as the material in the phone, any reason to suspect that George Zimmerman knew anything about any of it on February 26, 2012?
I don't know what George Zimmerman.
Certainly no communications to anybody
I
called
saw
George Zimmerman.
no text to Mr. Zimmerman.
Thank you, Judge.
Any redirect?
This idea of this mass deletion of text messages, where the text messages deleted seem to relate to certain subjects.
Certain subjects or certain people. It seems that text messages to and from certain people were deleted. Other ones were not.
Text messages about drugs and drug use that were deleted.
Yes.
Some of the text messages about the guns, trying to get a gun or sell a gun that were deleted.
Yes.
Is there anything that would indicate to you that someone other than Trayvon Martin got a hold of this phone and deleted a bunch of these messages all at once?
No.
Were there images of pornography on the phone
Yes.
that were not deleted?
Yes.
Well beyond the scope of the proper.
Same.
Your Honor, this directly relates to Mr. Mantai's claim that someone else could have deleted these text messages. I submit that if some family member got a hold of this, it rebuts what Mr. Mantai is suggesting.
Again, it has nothing to do with the scope of the proffer, which was only as to these exhibits.
Okay, it has nothing to do with the scope of the proffer. I understand your point. Go ahead.
Could you explain that, please?
Well, yes, there are the pictures of the gun were hidden also on the phone, and by a separate application that was on there. And what this app did not put them on the SIM card where pictures normally go, but it created a folder, basically in a program file, with a French language name, so it looked like it was a French language folder. And it put the pictures in that folder, and it also renamed the extension. The pictures taken with the camera are JPEG pictures, and they have a JPEG, JPG extension. What this app did was it also changed the extension of the pictures from JPEG to .bin. So in normal computer and digital data use, if, for example, you go to click on a bin file, your app's going to tell you, I don't know what this is, I can't open it. Whereas if you double click on a JPEG, it'll open up as a picture. So this app moved them and hid them, and again was password protected. And these were pictures that were not deleted off the phone. Whoever was using the phone would have to, again, have the codes to get to those items and know where they were.
Are you saying it's a separate hidden application from the one for the text messages?
Yes.
So there were two hidden applications that required a separate access?
Yes.
And the text messages were in one of them, and the pictures of the gun, among others, were in another?
Yes.
And that, if I hear what you're saying, the casual user of that phone wouldn't see those pictures unless they knew how to access that application.
Exactly.
And the application assigned a different file name so it would not appear to be a picture.
Correct. If you were just browsing the content of the phone, if say you had an app so you could browse the folders and files, you would see these as bin files and not as picture files.
Thank you.
Thank you. May Mr. Connor be excused? Can I have the exhibit?
You may.
Thank you. Will Mr. Connor be excused?
Yes, Your Honor.
Thank you very
Thank you.
much, sir. You may- Okay, the testimony's been proffered. I'll hear argument.
Your Honor, there's some additional evidence offered. As the court is aware, Rachel Gentile has been a witness in this trial, and that she also was deposed. She was deposed over a period of 2 days, a little over a month apart, and of course the state was present. And at her deposition in April of this year, while she had denied that Mr. Martin had talked with her about fighting, that in the deposition in April, she did then acknowledge that she'd had a conversation with Trayvon Martin where he told her that he was in a fight. And in fact, he told her that he knew how to fight and that he was in a fight that he won. We know from her testimony in trial that she'd only renewed her acquaintance with him after a number of years, in February 1st. So these conversations about fighting, knowing how to fight, having been in a fight that he won, took place within the couple of weeks prior to Mr. Martin traveling to Sanford. So that sort of closes the loop, if you will, on this authentication issue that I anticipate the state will argue. So we can offer the pages of the transcript, or the court can accept my proffer of the questions.
I'm sorry, I don't understand. Is it your proffer for the purposes of this proffer of Mr. Connor's testimony, or is it another proffer of something you want introduced in the trial, in front of the jury?
Your Honor, the larger issue is whether Mr. Connor will be allowed to testify as to the content of these text messages on Mr. Martin's phone. The court has already raised the question of authentication.
I just want what you just told me about the proffer of Ms. Gentile's deposition, is it for the purposes of this hearing or for the purposes of the trial?
No, for this.
Okay, thank you.
I have an excerpt of the deposition that I can just mark as an exhibit that references what I just orally proffered about that deposition.
I'm not saying I'm objecting, I'd just like to see which I said first. I have to make sure we're in context, please.
Mr. Mantei, I'll substitute one that's not marked for the exhibit, but you're welcome to review that.
Are we ready for argument?
Judge, I'm fine with the court accepting whichever.
Okay, that'll come in for this. Purposes of this hearing is defendant's exhibit number 5.
Number 5 will be the transcript.
Yes.
And did we?
I have the other exhibits here. I have, although they haven't been remarked by Lisa, but I'll give them to her in a moment. I'm ready for argument.
All right.
you want to mark these and then give them back to me? Thank you.
Before I forget, Judge, Mr. Zimmerman has a 10 o'clock curfew. May we have it extended until a reasonable time after
Yeah,
court?
it'll be extended for 30 minutes after court is concluded.
Is that enough? Thank you, Judge. Okay. So, on the argument part of this, we are asking that Mr. Connor be allowed to testify as to the substance of the text messages that he recovered from Trayvon Martin's phone, specifically as to the fighting. I think that's the core issue here. We laid the predicate for a picture, if it's otherwise relevant and we want to offer it, and for the pictures of the gun and the discussions about the gun. I'm not ready tonight to make the argument why the pictures of the gun and the discussions about the gun
I don't have the
are-
pictures of the gun. Defendant's Exhibit number 4 has 3 pictures of the profile of Mr. Martin.
There is an exhibit that was marked that has the discussion of the gun.
Right,
And,
that, I have that, but I don't have included in Defendant's Exhibit number 4, the first page is an extraction report with numbers 1, 2, and 3, and then it has 3 pictures of the same, 3 of the same picture. Those are the only parts of this exhibit. I don't have a picture of a gun.
Does the court have the exhibit that has the text messages referencing the gun?
Exhibit number 3 is an extraction report. Oh, yes, here it is. Well, let's see if the pictures are attached. There's an extraction report that has 4 thumbnails. Oh, here they are. They're attached to that, yes.
Yes, okay. And that has the gun and the hand on the gun?
Yes.
Okay. So I don't want to address that specifically tonight. The hour is late, and I'm not suggesting that Mr. Connor can, at this point, come before the jury and testify about the gun and the hand on the gun and the text messages, because I don't think that's been directly related, at least not yet, to the facts of the case. That would go more toward a notion of aggressiveness, maybe even a fact supporting a violent tendency. And
What part of the evidence code are you seeking to have this introduced? This information? All of the information that was proffered by Mr. Connor?
I believe that it most squarely is admissible under, well, no, it's different depending on what parts of the exhibit. The picture of Mr. Martin is simply that he has laid the predicate for a picture of Mr. Martin. That's not related specifically to fighting or guns. It's just a picture of Mr. Martin that was on his phone that shows his physique. That's the relevance of that. The pictures of the gun, the hand on the gun, the discussion of buying a gun and such is not directly related to the fighting issue. The fighting issue, the central core of the presentation, two legal grounds. One is 90.803. That's an exception to the hearsay, prohibition against hearsay that does not require the declarant, that the availability of the declarant is immaterial, and that it relates to an then existing mental, emotional, or physical condition. And in that primary text message with Lavandria, Mr. Martin is asked how he's doing, and he says he's tired and sore. And that's because he had just been in a fight that he had won, a fight.
What part of, I understand that, but I'm just trying to find out now, what part of the evidence code are you seeking to have that evidence admitted?
90.803.
All of them are 9803?
The text messages regarding fighting, I'm seeking under 90.803, and also under the legal authority of Chambers versus Mississippi, but that's a separate argument. I'm not addressing the admissibility yet of the firearm pictures, because I don't think that we've connected that up completely with the evidence in the, before the jury. So I'd like to concentrate on the evidence of fighting and why that's admissible under several theories. Not as reputation testimony under Munoz and such, but under 90.803 as reflecting a then existing mental, emotional, or physical condition. And that mental or emotional physical condition was at the time that Mr. Martin was in the fight, that he won the fight, and that he explained how he won the fight. He won the fight by, while losing the first round because his opponent was on top of him and rendered him helpless, much like the testimony was that he rendered George Zimmerman helpless in this case.
Okay, can I interrupt you for just a minute?
Mm-hmm.
So you're seeking it under 90.803 sub 3?
Uh-huh.
Okay, go ahead.
That's one of the legal grounds. That he talks about having been involved in, obviously, an orchestrated fight that was orchestrated for 3 rounds, that he lost the first round because his opponent was able essentially to take him to the ground and make him helpless by being on top. He also talks about how he won the second and third rounds and therefore actually won the fight. He also talked about how he was able to hit the person in the nose and make their nose bleed, but he wasn't satisfied that there was quite enough blood, so he talks about how he's not done yet with this guy. And of course, he's cautioned by this person that he should quit doing this stuff. That conversation about that particular orchestrated fight is corroborated by the conversation with Michael French that occurs within a few hours while he talks to Mr. French about this event having gone 3 rounds. So we know those are connected in time and in content. Certainly helping toward the authentication that those were the words of Trayvon Martin to 2 people that he communicated with regularly. Mr. Connor talked about how there were conversations with these folks on other subjects and that he extracted just that part of it that related to the fights. There's also a Facebook post by Trayvon Martin's younger half-brother, Demetrius Martin, and we can offer evidence in the record to connect up all the dots on that. Mr. Martin has several children. One of them, 2 or 3 years younger than Trayvon Martin, is Demetrius Martin. He identified all of that at his deposition. So we have more of the loop being closed that Demetrius Martin asked Trayvon Martin when he was going to teach him how to fight. Obviously, Demetrius Martin thought that Trayvon Martin knew how to fight enough that he would ask for his advice and training. We also know from the evidence, the proffer of the deposition of Rachel Gentile, that within the first couple of weeks of February that Trayvon Martin told her that he had been in a fight, that he had in fact won the fight. And we know that from Rachel Gentile, who obviously knows Trayvon Martin's voice and knows him personally, and testified that it was Trayvon Martin that told her about being in a fight that he had won. All of that is strong circumstantial evidence, if not clear direct evidence, that all of these conversations were by Trayvon Martin, his words being sent to his friends about a fight that he was proud he had won because he was able to draw blood from the man's nose and to ultimately prevail, even though he'd been in a difficult situation in the first round. So factually, we've connected the dots on authenticating this. Why is it relevant before the jury? Because, as the court will instruct the jury, the relative physical abilities and capabilities of the parties is relevant. There's a jury instruction that says just that. And this jury is going to be asked to decide who George Zimmerman was physically, what his physical capabilities were, as well as Trayvon Martin's physical capabilities. And that includes knowledge, that includes experience, that includes Trayvon Martin's experience in fights, having been put in a position of vulnerability by being put on the ground. However, of course, in that fight, it was an orchestrated 3-round fight. So when Trayvon Martin lost the first round, when he couldn't get up, whoever was refereeing it stopped it. And then they had 2 more rounds, which Trayvon Martin was able, by hitting this fellow in the face, apparently take steps toward winning. So that shows clear knowledge of Trayvon Martin prior to his contact with George Zimmerman, that he'd been in a fight, that he knew how to fight, and that he in fact knew what George Zimmerman would experience when he was on top of him, because the similar thing had happened to him in the past. We know that this is relevant because the state took great efforts to try to make that information relevant as to George Zimmerman. If the court will recall the testimony of physician's assistant Lynn Folgate, one of the things that the state took great pains to get this court to agree to, and ultimately to question Ms. Folgate on, was when Mr. Zimmerman spoke with her about his exercise regimen, that he had mentioned to her that he exercised aerobically with MMA. And the state made a big deal of that. They made a big deal about it in the case, that he had experience as MMA based upon the medical records from the Altamont family physicians, I guess it is. So we know these things are relevant because the state wants it to be relevant in their case. It's likewise relevant in our case because the jury is going to have to make that decision. So because I think that this information shows the existence of Mr. Martin's mental state shortly after this event occurred, because he's telling Lavondria that he's tired, that he's sore, that he had just been in a fight that he had won, that it is in fact admissible under 90.803(3), the existing mental, emotional, or physical condition at the time of the event. I'm not suggesting that that statement was him talking about anything in February of 2012, but it does in fact, on a relevant matter, show his thinking and his emotional and physical condition at that time. This is clearly compelling evidence in support of Mr. Zimmerman's self-defense claim. The testimony is that Mr. Martin sucker punched him, was able to by surprise, frankly, and then shortly thereafter was able to get him on the ground where he was mounted. We know from the testimony that mounting is when you straddle somebody around the area of the hips, and that it is an extremely vulnerable position because there are very limited acts that one can do, unless they are very skilled, to get out from under it. You are essentially helpless, and you are subject to the whims of the person on top. We know John Good said he saw Trayvon Martin mounted on George Zimmerman MMA style, and that we know from the physical evidence in the case, all of the physical evidence, frankly, especially the testimony related to firearms, corroborates that the shot was fired from the ground up, that the shirt was separated from the skin by somewhere between 2 and 4 inches, and that it exactly corroborates and is consistent with not just what Mr. Zimmerman said, but with what John Good observed some 10, 15, 20 seconds earlier when he went outside to investigate. So this is absolutely compelling evidence and is highly relevant and admissible under 90.803. We submit that it's also relevant because not to admit it in this case under these circumstances would violate Article 1, Sections 9 and 16 of the Florida Constitution and the 5th, 6th, and 14th Amendments of the United States Constitution that guarantees an accused to confront the witnesses and to present evidence in support of their defense, guarantees due process of law in presenting a defense. This theory, this constitutional principle of, if you will, preservation of the accused rights is discussed in the United States Supreme Court case of Chambers versus Mississippi. The court, I anticipate, is familiar with that decision, but what's to be taken from that decision is that a state's hearsay rules and such cannot be mechanistically applied to deny an accused the right to mount a defense. So I suggest that any application of a rule of exclusion because the court finds it to be hearsay or any other reason would be instead a mechanistic application of that rule that the Constitution of both the United States and Florida prohibits, especially under circumstances where it's clear that the evidence is reliable and trustworthy. We have closed the loop on all of this. It was Trayvon Martin's phone. It was Trayvon Martin's words in the context of all of the other words through the thousands and thousands of text messages that he had with others and with these individuals. He talked about a specific incident where he talked about his skill and the other person's skill in fighting, that he was able to injure the person, but he wasn't done with him yet. Completely consistent with what happened on February 26th when George Zimmerman was screaming for help, but Trayvon Martin wasn't done with him yet and kept on going and kept on going. We have indeed closed the loop the rest of the way with Rachel Gentel's deposition testimony, that within a couple of weeks of this event occurring, Trayvon Martin had been talking with Rachel Gentel about winning a fight, being in a fight, knowing how to fight. So this isn't something that the state can say isn't authenticated, isn't reliable, could have been somebody, anybody else just typing this stuff out. That's not at all credible. That can't possibly be the case now that you've heard the testimony of Richard Connor about these text messages, the context of these text messages, and of course what we've said here today about the highly probative value of this very, very relevant evidence. The default of this court should be to allow Mr. Zimmerman to present a defense, to guarantee his constitutional rights to present a defense. And this evidence is one step in that process. So we urge the court to allow Mr. Connor to testify about these text messages.
Thank you. Response?
But I think Mr. West is just that somebody's mounted another person and then they got off the ground. That's not in here. I mean, that's exactly why this type of evidence should not be before a jury. It is rank speculation. He's told a story that is not in these messages on Trayvon Martin's phone. We don't know, again, what type of fight he's talking about. If it's a slap fight, a play fight, a verbal fight, a wrestling fight, we don't know what it is. We don't know if the word fight is code for something else. We don't know anything about if there was a fight between Trayvon Martin and someone else. We don't know who his opponent was. Was he fighting Andre the Giant that he could lose a round to and then beat in a couple other rounds? Or was he fighting a little girl? I mean, that's why this sort of thing should not be admitted. That doesn't even address the authenticity issue. I mean, he keeps saying we've tied all the, connected all the dots. I submit to you he hasn't. We don't know who typed these messages. We don't know if they're connected. He said the message with Lavondra and to the other gentleman was hours apart. Actually, they were the next day. The message to, or the conversation with Rachel Gentel was weeks later, if not months later. Again, there's an authenticity issue, and they keep talking about the then existing mental state. We don't know when this fight was. There's no indication with any definitiveness as to when these fights took place. So,
I'm sorry to interrupt, except as a point of procedure, Mr. Manti did the cross, and now Mr. Guy is doing the argument. Are we allowed to do that here?
well, Judge, that's the way we designed it. It's my issue. I filed the motion in limine. Mr. Connor was Mr. Manti's witness. So that's why we found it this way. That was his witness and my issue.
Okay, go ahead.
This was the issue I argued before the court. Judge, so again, we've got an authenticity issue. We've got whether or not it was then existing mental state. Again, there's no definitiveness as to when these events occurred. But most importantly, we don't know exactly what was meant by these words. Are they code for something else? You know, and again, the danger is exactly what Mr. West has put before the court, that there's an orchestrated fight, that there's a referee, that there's mounting going on, none of which is in here. There's talk about being on the ground. That's it. It is not competent evidence. If there's any probative value, it's outweighed by the prejudicial effect of what a jury might imagine was meant by those text messages that may have been sent by Trayvon Martin and may have been about a fight. Your Honor, I don't know if the court wants me to address the issue of the photograph. I think it's Exhibit 4 or the information purportedly about a firearm.
The firearm, Mr. West said he wanted to address at a later time, so you don't have to address that.
Your Honor, the photograph appears to be Trayvon Martin, but they said they offered it for, I can't remember the term he used, but the best photograph of Trayvon Martin for this jury to consider is the one of him on the medical examiner's table that was taken just shortly after his death. We don't know if when this photograph was taken. We don't know if it was something that he took right after he worked out and got all pumped up and maybe took a picture of himself for that reason. We just don't know. But the best photograph are the ones already in evidence that were taken at or about the time of his death. So for that reason, I see no probative value to the photograph, as we already have that in evidence. If I can just have a moment. And Judge, they relied on Chambers versus Mississippi. Again, I don't think the purpose of that is to eradicate the evidence code and to allow into evidence items that are subject to the type of speculation and misinterpretation that this proposed evidence is. So I would ask the court to continue to grant the state's motion and deny this evidence. Thank you.
Thank you. Any further argument?
Only brief response as to the authentication issue specifically. Well, first of all, as to the content of the text messages, they are what they are. I'm not suggesting that we should be allowed to explain them when they're offered to the jury. The jury will see them and give them whatever weight they choose to give them based upon what they believe them to mean. As to the authentication issue, this issue is mired in the mess that discovery on this issue has become. There is a pending motion for sanctions before this court that will be taken up at the end of the trial because Mr. Della Rionda stood before this court and said, we gave the defense everything. We offered the testimony of Wesley White, we offered the testimony of Ben Credos, that in fact wasn't true. And we finally got the report from Mr. Brenton at FDLE on June 4th. June 4th, and we still haven't had a chance to go through it because we had the Fry hearing, we've had 2 weeks of jury selection, and what is this, our 3rd week of trial? I can't even keep track of time. There is an ongoing discovery issue, violations. In fact, Mr. Guy stood there silently when Bernie Della Rionda said, we gave him everything, there's no other report. We didn't get any information from anybody different than what we gave them. And we know that's just not true. Mr. O'Mara said to this court, let's relax some of the authentication issues, if nothing else, because we can't get through this issue with the timetable the court has set. There is no authentication issue. In fact, the authentication issue that Mr. Guy raises is illusory. And to the extent that this court thinks there is one, it's because of the state's misconduct, not because of anything that
Well,
we've done.
even if you were to take everything out of that bin file, it would still be the same issue. It's coming from the same phone.
We did not have the ability,
Well,
we were misled, Judge. We
Well,
were given a
Go ahead.
we were given a report at the same time we were given the bin file in late February. The report was misleading. It did not contain the same information that the state had in its possession at that time. We got the report, which was
Mr.
incomplete.
Connor testified that he found 600 additional photos that the state didn't know about, so
That's not true. That's just not true.
I thought I heard him say that. I'm
Well,
sorry.
that's what he said, but that's not true that the state didn't know about them. We had testimony before this court from Ben Kritos
Okay.
that he
We're getting
printed
off
2
on a really
reports.
side issue, because my point being is, if you had 5 years to look at that bin file, it's still coming from this same phone,
We
correct?
only wanted an
It's
extra
still
week.
coming from this same phone, correct? Yes.
The data
So
set
what-
is the data set, yes.
Okay, it's still coming from this phone. The information that you're seeking now to introduce through Mr. Connor, I do have an authentication issue about it. 90.901 is the requirement for authentication or identification. 90.901A, 901.1A, and I'm reading from Earhart. The most common method to authenticate the electronic record or message is by the testimony of a person with knowledge who created the record or message of that printout accurately reflects the contents that the witness created or sent. And it goes on and it brings you to footnote number 3, and it references Griffin versus State, 419 Maryland, 343 19 A 3rd 415 2011, and State versus Ellick, ELECK, 130 Connecticut Appeals, 632 23 A 3rd 818 2011 case. An electronic document, example, email, text messaging, and networking sites like Facebook, may continue to be authenticated by traditional means such as the direct testimony of the purported author or circumstantial evidence of distinctive characteristics in the document that identify the author. Typically, electronic messages do have self-identifying features. For example, email messages are marked with the sender's email address, text messages are marked with the sender's cell phone number, and Facebook messages are marked with a username and profile picture. Nonetheless, given that such messages could be generated by a third party under the guise of the named sender, opinions from other jurisdictions have not equated evidence of these account usernames or numbers with self-authentication. They cite another case of Commonwealth versus Purdy, 459 Massachusetts, 442, 945 Northeast 2nd at 372, 2011 case. Evidence that electronic communication originates from email or social networking website that bears purported author's name is not sufficient alone to authenticate it. Another case, they cite emails authenticated not only by defendant's email address, but also by inclusion of factual details known to the defendant that were corroborated by telephone conversations. And my point being is that what has been presented to the court, Exhibit 2, Exhibit 4 is the profile picture. Exhibit 2 and Exhibit 3 has nothing identifying Mr. Martin. He doesn't say, hey, this is Trayvon, or it has going out to Lavandria, coming back in from Lavandria. It has the phone numbers, it has the time, but anybody could have picked up that phone and sent these text messages. A third party could have access to it. People have children who pick up their phones and play with them and send text messages to their friends or other people. I don't have any identifying marks that these text messages are created by or sent by Mr. Martin. I have a concern about that.
Well, we know the phone had a double level of security. We know
Well,
that.
and I know any 7-year-old can learn the passwords and get into that because they do it all the time.
FDLE couldn't do it for a year almost.
Well.
They sent this phone all over the country, and they had to write code for it.
But a person
with-
may know that password. Another person may know that password. FDLE didn't know the password.
Right, it's evident under 90.901 that there's evidence sufficient to support a finding that it is what we claim it to be. All of this came off of Trayvon Martin's phone. There are thousands of pictures, thousands of text messages, no indication that anybody else was using his phone. Mr. Connor looked at all of those text messages. Further, under the authority of is it Manuel?
Yeah, it's on the same page.
Manuel v. State, is that the one you're talking about? 357 Southwest 3rd, that one?
Yes.
Cited in Earhart's book, I guess, Mr. O'Mara pointed this out to me, to suggest, I don't know what else we could do under these circumstances when the state didn't give us the information timely.
But
We
even if the
didn't-
state gave you that information, is my point, what on these text messages identify that they were created by Mr.
We
Martin?
would have had the time and the opportunity to find the witnesses on the other end, first of all. And we have not had that because of the state withholding valuable, exculpatory, probative evidence in this case repeatedly, and then misrepresenting to the court what they did. And then finally, when we caught them doing it, we get it on June 4th. Judge, I don't know what else we could have done, frankly. We asked for time. We wanted to depose Steve Brenton. We asked the court to delay the case a few days. I don't know what else we could have conceivably have done under the circumstances to further this authentication issue under the circumstances that the state is solely responsible for. It's simply unfair for Mr. Zimmerman not to be able to put on his defense because of the state's tactics. It was a strategy, obviously, because they had it in January and kept it from us, made us spend 10, 20, 30, 100 hours digging it out, playing games with us, lying to this court, and now it's our fault. It's our fault. To deny Mr. Zimmerman the right to present this information violates both the Florida and the United States Constitution.
I'm not getting into this. Court is in recess. I will give my ruling in the morning. I'll see you at 8 o'clock in the morning.
May we
Court
have-
is in recess. It is
It's 10 o'clock at night.
9:56.
Okay.
No, court is in recess. Thank you very much. With all due respect, we'll see you at 8 in the morning. Well, at 8 in the morning, the issue is Mr. Donnelly, who may have violated, or counsel has informed the court that you know that he violated the rule of sequestration. That's the second time today that I've heard that there's been a violation of the rule of sequestration by the witnesses. I don't want to take that up at 9 o'clock and have the jury sit out there and wait like they did today. We will be in recess until 8 in the morning.
I've been in the courtroom for the
And
last 6
so
hours.
have I.
Not being able to prepare or get my witnesses gathered for tomorrow, and I can't do it tonight.
I'll see you at 8
Judge,
in
I'm
the
not
morning.
physically able to keep up this pace much longer. It's 10 o'clock at night. We started this morning. We've had full days every day. Weekends, depositions at night. Thank you.